in Abuja, where the Supreme Court has dismissed the suit filed by the People's Democratic Party challenging the eligibility of the president-elect to contest the presidential election that was held on the 25th of February. The PDP argued that the manner the APC and Bola Tinubu nominated Kashim Shettima as a vice presidential candidate for the election was in gross breach of the provisions of the Electoral Act. The Supreme Court held that the plaintiff must show harm or substantial harm done to him by the action he is complaining about. It also ruled that no political party can challenge the nomination of the candidates of another political party, and the matter being a pre-election matter has a time limit. The court described the suit was a waste of the court's time and awarded a cost of 2 million naira against the plaintiff in favor of the respondents. All right, so let's get more on this development. TVC News judiciary correspondent Celestina Area joins us from Abuja to help us put a context to this matter. Celestina, let me start with you. I understand I will also be having a lawyer, Jide Ologun, to discuss this. But before we get to you, Jide, let me first start with Celestina, who was in court. Well, it seems this is the end of the road for the People's Democratic Party. Can you give us a context on this matter? I hope you can hear me. I'm asking that it seems this is the end of the road for the People's Democratic Party, considering the matter they brought to the court concerning the eligibility of the vice presidential elect, that's Kashim Shettima.
To the appeal filed by the People's Democratic Party. The appeal emanated from the Federal High Court, moved over to the Court of Appeal, and also very well, Sarah, I can hear you loud and clear. I said that the suit emanated from the Federal High Court, then moved over to the Court of Appeal, now at the Supreme Court, where it was decided today. At the Federal High Court in Abuja, Justice Iyan Eku said that he lacked jurisdiction because the plaintiff did not have the local standing to institute the suit. He anchored his judgment in line with Section 29 of the Electoral Act, which says that it's only an aspirant of a primary election that can challenge the primary election. So far, so good. The PDP did not show the court any reason as to why harm will be done to them or injustice was done to them considering the nomination of Kashim Shettima. And the court also said that that particular suit brought by the PDP at the trial court, which is the Federal High Court, was caught by the principle of estapo judicatur, which says that, which is a principle that stops adjudication of a particular case which has already been decided. There is a judgment, a subsisting judgment of the Federal High Court that had already decided on this very case before the PDP brought the case to the Federal High Court. The PDP, dissatisfied with the judgment of the trial court, moved to the Court of Appeal. The Court of Appeal also dismissed the PDP's appeal and awarded the cost of 5 million naira, still also citing the position held by the trial court, where it says that the PDP, they were meddlesome interlopers, busybody. They had no locus to first of all, in the first place, institute the suit against the president and the vice president-elect. Now, at the Supreme Court today, the Supreme Court was extensive in its judgment. It cited examples as to why the suit failed and was bereft of merit, and the court lacked the jurisdiction. Firstly, the court talked about the stand, the PDP, to bring the suit. The PDP anchored the suit on, said that the vice presidential candidate, or I beg your pardon, the vice president-elect is in violation of Section 29, Section 33, Section 35, and Section 84 of the Electoral Act. But the court today said that Section 29 does not apply because the PDP were not aspirants in the primary election or the nomination. And so far, so good. What the court said that the vice president-elect submitted his resignation or a letter to the party stating them that he is withdrawing from the race of being a senator and accepting the nomination of the vice president. According to Section 142 of the Constitution, his appointment is an associate of the president. So it has nothing to do with double nomination. They also made reference to the case of Uche Wonsu in 2018 and the judgment delivered by the Supreme Court. That case did not apply because Uche Wonsu, as the Supreme Court found today, was a candidate of two political parties. He was nominated by two political parties, not the same political party. But the court also took us back and gave an example of 1999, wherein Atiku Abubakar won the governorship election in Adamawa State and also got nominated to be the vice presidential candidate of the PDP to run alongside Olusegun Obasanjo. He abandoned his ambition of becoming the governor to pursue his ambition of becoming a vice president. But his deputy wanted to step in as governor or inherit that position where the INEC had challenged that saying that they would conduct a re-election. But he went to court, up to the Supreme Court, and he got judgment. So the justices of the Apex Court today asked the PDP that what has changed from 1999 to 2023, that now they are coming to challenge the candidacy of Kashim Shettima, seeking the nullification of Bola Tinubu's election. So the court said there is no basis at which it will grant the reliefs that the PDP is seeking, that the PDP has no stand, the appeal lacks merit, and the appeal was even statute barred because the 180 days prescribed by the lower court and the 60 days by the appellate court to decide on this case have elapsed.
All right, Celestina Area, thank you so much for that insight. Let's bring in lawyer Jide Ologun to help us understand the position of the court. It's pretty interesting what we've seen in the court today, and of course we still have more interesting days to come in the court as we anticipate the May 29 inauguration of the president-elect in person of Bola Ahmed Tinubu. The three courts inched their position on the issue of legal standing. Jide, that's the legal standing of the plaintiff now. Help us understand the position of the court.
Thank you very much. The position of the court is that the issue before this court is an issue that concerns a member of the APC party who could have been affected even where you have complaints of nomination. And PDP has no business in how the APC nominated their candidates. And that is why the Honorable Justice made reference to PDP to have acted as an intrusive interloper and a busybody. And of course, by extension, if you want to simplify it, a busybody or interloper is someone who trespasses, an alien to an issue. So there is no way the PDP has a say in this matter. And before the matter arrived at the Supreme Court, those were the decisions of the previous courts. And, my advice is that also, since we have these laws written down, particularly the Electoral Act 2022 as amended, it should be instructive sometimes before litigants go to court to study the provisions of the law and be sure they are not just out to waste the time of the court, even though the court is always open to those who want to embark on litigations. And recently, at the appellate level, the matter was also dismissed and the lawyer was slammed 40 million naira for coming to waste the time of the court. But the court declared that initiating that case was frivolous, vexatious, and it was qualified as an annoying lawsuit to irritate the respondents, and Uru was sanctioned for this blatant abuse of the legal system, so that we don't just belabor the judiciary unnecessarily. And this has put to rest now the issue of nomination in APC. And this is also one of the issues that may feature during the electoral tribunal when that starts trial fully. So now this has been laid to rest. And this is about the last straw that is breaking the camel's back in an attempt to stop the swearing in of the president-elect tomorrow. Because if the Supreme Court decided otherwise, being the highest court in the land since 1963, it would have disrupted the scheduled swearing in of the president-elect tomorrow.
That's on Monday,
after the swearing in of the president, the tribunal, the Presidential Election Tribunal, will commence trial 30th of May, the day after.
Pretty interesting times that we're in, but this defeat comes at a cost. The court had fined them, awarded a 2 million naira cost against the plaintiff in favor of the respondents. I want to ask you, what lessons can we learn from this judgment?
I think that is it's quite considerate of the court to have, granted such a meager penalty in terms of finance. I made reference to a case recently where the court slammed 40 million naira on the lawyer for bringing such a vexatious case to the court. And the lesson here, I've mentioned it earlier, even if you are not a lawyer, please, nothing prevents you from studying the laws that will form the bedrock of your argument in court or your lawyer's argument in court, so that you are proactive and know whether to go to court and waste time or not to go to court. And in law, we say some matters are clear on the face value of it, prima facie. So it's after when you do your own layman study and you are probably persuaded that you have a strong matter that you go to court. And from the way the judiciary is responding lately, I believe that going forward, coming to court with vexatious matters will dwindle in the nation, because it's indeed a waste of time to pursue this matter. I did a little bit of research on this matter before today's decision, and I wasn't surprised when eventually the Supreme Court came up with this verdict, because I have pinpointed that issue that PDP has no business in the nomination of the candidates for APC. And here we are today. And in the light of this, maybe those who are in the Presidential Election Tribunal will look at their cases again and then take a decision. And again, I want to appreciate all the stakeholders and advise again, like I have been doing. Please, let's calm down. Don't let us be sensational about any matter, whether in the tribunal or wherever.
Yeah.
And attend to the facts, the issues of law in these matters, so that people won't come out and say, judiciary is this and that. The judiciary only adjudicates based on the facts you present before them. And you have the responsibility to establish your case. And you can look at Section 131 of the Evidence Act to that effect. And talking about the
I'm afraid we might have to leave it at this point here. Lawyer Jide Ologun, thank you so much for giving us insights into that. Subsequently, we'll definitely bring you to help us understand the position of the court and the role of lawyers in judicial matters. You're watching